the circumstantial evidence then that may exist, and they've tried to present to you that my client is some, well, I'm not exactly sure what the state's case is yet, but to the extent that what they're trying to say to you is that my client was a frustrated neighborhood watch and cop wannabe and just sort of had enough, and that is supported by some circumstantial evidence. I don't think that they have any direct evidence to suggest that. In effect, what they have shown is that my client has in fact been frustrated because he's called before, and on occasion the people he's called on have gotten away. My client's immediate statement to those who listened to him that he was screaming for help before he knew that that was being recorded. We can have an argument that he's this new cop wannabe who would know that it's going to be recorded, but the reality is the first person on the scene he told it to, the second person on the scene he told it to, the officer, that's Manalo and the officer, and he has the undeniable injuries that evidence nothing other than a violent attack by Trayvon Martin. There is no other reasonable hypothesis that could come from that undisputed evidence other than my client was attacked by Trayvon Martin. That violent act in and of itself, I would suggest to you, is sufficient for immediate response with deadly force. But he didn't. What we have is 40 seconds of somebody screaming. Of course, you know, my client, through his statement, said it was him screaming. 40 seconds, and receiving additional injuries consistent with, and even the state's own experts said it was consistent with, my client's head being bashed against concrete. To date, and the state's case is now done, to date, they have not presented any direct evidence, and I would suggest not even circumstantial evidence, that my client followed him after being told not to by the dispatch. They have no direct evidence, no circumstantial evidence that my client ever moved from the T intersection down the dog path until he was drugged or forced there by Trayvon Martin. There's not a scintilla of evidence to support that. My client never attempted to, nor landed one blow upon Mr. Martin. All my client did was scream out for help. Mr. Good, though he was questioned a lot about this area, did finally, I think, opine, though he didn't see gas escaping from my client's mouth as he was the one screaming towards him, but he said that it was his thought and his common sense that it was, in fact, my client screaming out for help. And the reality is, had it been Mr. Martin, who we now know, and it's undisputed, was on top screaming for help, well, he had his chance. He had Mr. Good 17 feet away, asking him to stop, telling Mr. Martin he was going to call 911, and Mr. Martin continued to ignore him and continued to batter my client in whatever form or fashion, or however number of times he did, that ended up with the injuries that my client had. They can't ignore that evidence to a jury, and they really should not be able to ignore it to you on a judgment of acquittal argument. We know who had the injuries. We know who didn't. It was a sad and tragic affair, but Trayvon Martin did, in fact, cause his own death, and this man should not face a jury any longer than he has already.
Thank you both very much for your arguments. I have reviewed all of the case law and listened very closely to your arguments. The court finds that the state has presented sufficient evidence, both direct and circumstantial, to allow its charge to go to the jury. The motions for judgment of acquittal are denied. You have a witness that's ready.